Welcome, everyone. Today we'll be discussing probationary employees and the important aspects surrounding their rights and appeal processes. This period is crucial for both the employee and the organization as it allows time for assessment and adjustment. We'll explore the key rights that probationary employees hold, the steps they can take if they feel those rights are compromised, and the best practices for both the employers and employees during this transitional phase. Let's dive in. Here's an overview of the topics being discussed. Definition of probationary employee, procedural rights, termination rights, reasons for appeal, and dispute resolution options. What is a probationary employee? A probationary employee is someone hired on a temporary basis for evaluation during a predetermined period, typically lasting 1 to 2 years depending on appointment. This probationary period allows the employer to assess the employee's performance and fit within the agency. Both parties can evaluate their compatibility during this time. At the end of the period, the employer decides whether to offer a permanent position, extend probation, or terminate employment if expectations are not met. Probationary period by appointment. Both Title V and hybrid Title 38 or competitive service appointments have a 1-year probationary period. Title 38 or accepted service appointments are generally a 2-year probationary period or 1 year if the individual is preference eligible. Procedural rights. Due process rights for probationary employees vary greatly depending on several factors: their service type, whether they be competitive or accepted, the reason for termination, and whether they are preference eligible. For Title V and hybrid Title 38 competitive service probationary employees, some of those procedural rights are limited to notice of the reasons for the proposed termination, reasonable time to respond to the notice and provide supporting evidence, written notice of the agency's decision, including reasons and notification of appeal rights, as well as the right to an appeal to the MSPB if the termination did not follow the procedural requirements. Title 38 accepted service probationary employees do not have the right to appeal their termination to the MSPB. There are limited exceptions based on the length of service and preference eligibility. Regardless of service type, probationary employees may have other avenues for review, including filing an equal employment opportunity complaint, a grievance, or a request for corrective action with the Office of Special Counsel. However, pursuing one option might limit or preclude others. Termination rights. Probationary employees in the competitive service have limited appeal rights. These rights depend on why the individual was terminated. Probationary employees in the accepted service generally have no right to appeal their termination to the Merit System Protection Board. There are limited exceptions for preference eligible, those with at least a year of continuous service, and non-preference eligibles, those with at least 2 years of continuous service, but these are uncommon. Reasons for appeal. Here are the grounds for appeal according to the MSPB. Competitive service employees. Pre-appointment reasons. If a person is terminated for reasons that existed before their appointment, they can appeal if the agency did not follow the required procedures as outlined in 5 CFR 315, 805, and 806. For post-appointment reasons, if terminated for reasons arising after their appointment, they can only appeal if the termination was based on partisan political reasons or marital status. Discrimination based on race, color, religion, sex, national origin, age, or disability can also be raised in the context if they've already raised either marital status or partisan political discrimination. Note that the MSPB only reviews procedural issues, not the validity of the termination itself. For accepted service employees, generally there are no regulatory appeal rights for probationary employees in the accepted service. There may be limited exceptions based on length of service, 1 year for preference eligibles, 2 years for non-preference eligibles. It should also be noted that Veterans Recruitment Appointment appointees have the same appeal rights as competitive service employees. Dispute resolution. In the context of adverse actions and probationary employment, the Merit System Protection Board outlines several mechanisms for resolving disputes, which typically include informal discussions. Before pursuing formal action, employees may engage in formal discussions with supervisors or human resources to address concerns and misunderstandings. Number 2 is grievance procedures. Many agencies have established grievance procedures that allow employees to formally raise issues regarding workplace disputes, including adverse actions. These procedures often involve a series of steps starting with a written grievance and potentially leading into a hearing. Number 3 is mediation. Some agencies may offer mediation services as a means to resolve disputes amicably. This involves a neutral third party helping the disputing parties reach a mutual agreeable solution. Number 4, formal appeals. If informal measures fail, employees may have the right to appeal adverse actions to the MSPB. The board will review the case to determine if the actions was justified under the law and agency regulations. Number 5 is alternative dispute resolution. This approach includes various methods for settling disputes outside of formal litigation, such as arbitration or facilitated discussions, often aiming for quicker and less adversarial resolutions. Number 6, union representation. For unionized employees, their union may represent them in disputes, providing support and advocacy throughout the process. Here's a link for the information used for this training by the U.S. Merit System Protection Board. We're pleased to announce our updated training format, which now offers concise and easily accessible lessons. We welcome your suggestions for potential new topics and encourage you to share your thoughts by reaching out to us via email at VISN8HRD@va.gov.